I'm Judge Jim Edwards. I'll be presiding. I have the pleasure of having Judge Meredith Sasso and Judge Wozniak also on the panel with me today. We're here on case number 21-2310, Kenneth Sink versus Bradley Heath, etc. And we're here on a motion for sanctions, order to show cause why sanctions should not be imposed against attorney Ovid Val. So, Mr. Val, I'm going to make this rather short, but essentially what has been occurring in this case, you missed at least one deadline for filing and advised the court in response that you had your paralegal try to file things unsuccessfully. We accepted your response and reopened the appeal, let your client's case go forward, and advised you at that time in an order dated April 29th that you were to review the rules and regulations regarding how electronic filing is to be done, and that you were to file an affidavit within 10 days of that April 29th order, simply acknowledging that you had reviewed the rules, understood them, and had explained them to your staff. 10 days came and went with no affidavit. So we then filed an order May 19, 2022, reiterating the fact that you had not complied with our April 29th order and set this hearing. In that May 19th order, we had the simple direction that you were to acknowledge within 5 days that you had received the order. You did not comply with the time frame in terms of filing an affidavit in response to the May 29th order, nor did you respond in time with regard to the May 19th order. We received filings, one that was filed this morning at 10:58 a.m., advising that this was in response to our April 29th order. And you filed another one at 11:27 last night, trying to, I guess it was in compliance with or trying to comply with the May 19th order. In neither one of those responses do I see any explanation for why they were not filed on time. Why don't we start with that? Why, when we sent you an order dated April 29th, directing you to respond within 10 days, why didn't you do that?
Okay, good afternoon, Judge. The first thing I want to say is I've been practicing for about 22 years, and this is not typically what goes on with me or how I practice. I kind of have to back things up a little bit and I want to try to get the dates in my head correctly.
Can you speak up a little bit more or speak more directly into the microphone? I've got my volume turned all the way up and having a little trouble hearing you.
Oh. Okay, can you hear better now?
Yes, thank you.
Can't see anybody. Okay, I was just saying that this is typically not the way I practice, and this is not typically what happens. I've been practicing for 22 years, and I'm an attorney in good standing. I just want to back up a little bit to, and I want to get the dates right in my head. I've been dealing with a lot of medical complications, and I was initially diagnosed with, and I'll provide whatever documentation the court requires. I was diagnosed with something called chronic kidney disease, and I'm about a stage away from dialysis. And I was dealing with some medical problems dealing with that, and very tired. And I kind of caught up with what was going on about 2 weeks ago, and I've been trying to get caught up with everything because I fell back with a lot of things. Back in sometime around halfway of April, I was just sick, and I couldn't seem to do anything. I've never had a primary care doctor. I went in, I got one, and on April 1st or 2nd, I came in and I had all kind of like symptoms. I was like my lymph nodes, my neck was like gigantic, and I just didn't know what was wrong with me. They started giving me lots of medication, one of the things that was wrong, the health department called me on the 7th of May or the 9th of May, and they said that I was positive with COVID, and my primary care was telling me that because I have what they call pre-existing kind of conditions, that it's having different types of effects. There's all kinds of effects on me, and I've been kind of dealing with that. Like, for example, just Sunday night, I had to go to the emergency room, and they had to give me morphine and some other thing because now they think something might be wrong with, of all things, my gallbladder. And I've been dealing with this case and with a bunch of other cases. And with this particular case, I was dealing with a paralegal and he works with me a lot. And I was trying to make sure I don't fall behind. And maybe I just didn't read these orders carefully enough, or I just skimmed through them. And it was a failing on my part. And when I started realizing everything that I far behind, I was just trying to get caught up. I was trying to get the last orders in earlier to the court, and it took up until really yesterday for me to get everything together. I don't believe that this will in any way prejudice the case. It's just that I've been dealing with medical problems. If the court wants anything from the health department for my primary care, I'm willing to provide. Whatever's been going on, even my stay at the emergency room Sunday night, I've just been going through just medically a lot. And
well, Mr. Val, I'm very sorry to hear that. Nobody is at 100% for sure when they're ill. However, none of what you said has been put in the record before. I mean, before it was, I didn't see anything, and correct me if I'm wrong, but the reason you gave for not timely filing a brief in response to the court's order was you were having difficulty with e-filing, and you were trying to file or trying to have your paralegal file them in a manner contrary to the rules. Our April 29th order was hardly punitive. It was intended to make sure you understood what you needed to do to file things. And
yes,
rather straightforward in terms of what it asked you to do, what it ordered you to do. And you didn't do that until this morning. And likewise with the simple acknowledgement of the order of May 19th. You know, all you had to do was to file a paper saying we got it. And we know from our clerk of the court's office that you got the order when it was sent. I mean, it's not something that you just got last night or this morning. And, you know, I understand you were ill. I understand how you can fall behind and all the rest of that, but I don't understand when a court directs you to do something that is really simple. Under anybody's view of things, it's very simple. When you choose not to do that, that certainly demonstrates a lack of professionalism on your part. If you had told us you were sick and that was the reason for your problems and that you needed extra time, we've had other counsel who has had COVID and other diseases and other conditions. And when we know that, we can deal with it accordingly. But when all we get is your clerk won't let me file papers, that is no indication to us of you being ill or any reason for you not being able to file it other than you're unfamiliar with our practices. We have we entered these orders for a reason so that you would understand how to file and move forward. We, you know, again, I'm very sorry for your health issues and problems. There's nothing we can do about that other than be understanding. But by the same token, your client and the opposing party deserve to have the case resolved in a timely fashion. And so far, you've not been a part of getting it determined in a timely fashion. You know, and again, filing these things late, you don't even explain until today why you filed them so late. And again, that's to me a reflection of a lack of professionalism in the way you're going about things. Again, if you had told us when you got these orders, or had your paralegal prepare something for you to sign and file saying, I'm ill, I've fallen behind, can I have extra time? Once again, we would be understanding. But when we were met with basically a refusal to comply with an order with no explanation on the record until today, it's kind of hard for us to understand why you would go about practicing law that way. I'm glad to hear you say that that's not how you practice law typically. And I hope that you're feeling better and can get better. But I can tell you that this court intends and prides itself on being able to move cases along, not rush them along, but move them along so that people's cases can be determined and an outcome can be reached and the parties can go about their business and their life. And we're going to hold you, like we hold other lawyers, to that same standard. And if you can't comply with that standard, then perhaps you should talk with your client and make some other arrangement so that your client has a lawyer who can comply. If you can comply, we're going to hold you to it. Do you understand?
Absolutely, Your Honor.
All right. I don't know if any of my colleagues have anything to add. All right. Well, we will. And Ms. McChrystal, I understand you're here. I don't have any questions for you, and I don't really see any particular reason other than to acknowledge your presence that we need any input from you on this. So I hope you understand you're not being ignored. I just don't think we need anything from you at this time. So Mr. Val, my colleagues and I will confer, and we will determine what, if any, sanctions would be appropriate. So with that, we will be in recess. Thank you.
Thank you.
Thank you.